Today, I will discuss the recent High Court case of Foglia and Family Officer Limited of March 2021. This case illustrates the importance of the interaction between traditional legal remedies and technical IT expertise to discover the relevant evidence, trace stolen funds, and expose fraudulent scams relating to email spoofing and social engineering fraud. I will now summarize the facts of this case. The claimant was a victim of a fraud which misappropriated 15 million euros from a bank account held in the Cayman Islands. The fraudster impersonated the authorized signatory of the claimant in telephone calls and a fax to the Cayman Islands bank. The monies were traced to a bank account in England held by the first defendant, TFO, which was wholly owned by the fourth defendant, Mr. Carey. In order to recover the funds, the claimant issued non-party disclosure order applications against the bank, financial institutions, and the telephone company. Against the fraudsters, the claimant issued proprietary and freezing injunction applications, initially against persons unknown, and then against the defendants when they were identified. As a result of these orders, the claimant recovered 11.5 million euros from the 15 million euros which had been stolen. In relation to the 3.5 million euros that was outstanding, plus interest and costs, the claimant advanced proprietary claims and claims in knowing receipt, dishonest assistance, and unjust enrichment against the defendant. Subsequently, the claimant made a summary judgment application arguing that the defendants did not have any real prospects of successfully defending the claims in a trial. And it is in relation of the summary judgment application that the High Court has handed down its judgment in this case. The main defense by the defendants who were subject to the summary judgment application issued by the claimant was that Mr. Carey, the fourth defendant, was the victim of, was the victim of the fraudster himself. Therefore, that Mr. Carey and the defendants were innocent. To support this innocence defense, the defendants relied on two arguments. First, that there was no proof that Mr. Carey had the necessary information in order to impersonate the authorized signatory of the claimants and send the instructions to the Cayman Islands bank. Second, in relation to the payments that were made out of the 15 million euros that had been received by the first defendant, TFO, Mr. Carey, who controlled TFO and was the fourth defendant, said that he had authorized these payments because they were payments made pursuant to an investment agreement between himself and one Mr. Aloshi, who was connected with the claimant. And to support this, Mr. Carey relied on two pieces of evidence. First, handwritten notes of his negotiations with Mr. Aloshi, and second, several email exchanges between himself and Mr. Aloshi. Subsequently, Mr. Carey accepted that the emails purported to be from Mr. Aloshi were spoofed emails, but Mr. Carey said that it didn't matter because he, Mr. Carey, believed that he was making these investment payments pursuant to the investment agreement, which he believed he had entered into with Mr. Aloshi, and therefore Mr. Carey was innocent. In relation to the evidence available before the court, for the court to decide on the summary judgment applications, there were two main types of evidence that the court concentrated on. First was the phone mast evidence. Second, the spoofed emails. In relation to the phone mast evidence, this was evidence that was obtained pursuant to Norwich pharmacal disclosure orders, which were obtained from Vodafone and from the bank from which the payment to purchase the mobile phone and the SIM cards had been made. And that phone mast evidence showed that the phone, the mobile phone, the handset, and the SIM card had been purchased from the bank account, the bank card belonging to an employee of TFO, and that Mr. Carey had paid £200 to that employee on the day before that phone call to the bank was made. The phone mast evidence also showed that the phone call to the bank had been made less than 100 meters from the office of TFO. In his defense, Mr. Carey explained that he had handed over the handset and the SIM card to an associate of Mr. Aloshi, and that it would be a clash of improbabilities, that completely unconvincing, that he would have made, if he was the fraudster, that he would have made the phone call from a mobile phone that was traceable, and that he would have made the order of the transfer into a bank account of a company that he controlled. And he also said that probably the fraudster was trying to set him up by making the phone call so close to his office. However, the court held that these explanations of the clash of improbability to explain Mr. Carey's innocence, it was all presupposed on Mr. Carey's knowledge of IT technical tracing matters, which was unconvincing. And also that it was very unconvincing that if a fraudster would have allowed the transfer to be made from the claimant's bank account into a company controlled solely by Mr. Carey, giving Mr. Carey complete ability to transfer the money wherever he wished. And this pointed to the fact that Mr. Carey was, if not the only fraudster, he was involved in the fraud. In relation to the spoofed emails, the second main type of evidence that was available before the court, Mr. Carey used the spoofed emails, the trail of emails between himself and Mr. Aloshi, as evidence of the investment agreements between himself and Mr. Aloshi, who he argued was connected with the claimant, and therefore that he had ordered the payments out of TFO pursuant to this investment agreement, and therefore he was innocent. However, the court said that despite 7 letters asking Mr. Carey to produce native format copies of the emails which he had sent from his email account to the spoofed email account of Mr. Aloshi, Mr. Carey failed to produce native format copies of the emails that he said he had sent to the spoofed Mr. Aloshi's email account. And therefore, that could only point to Mr. Carey being involved in the fraud. And this was the main basis for the court to grant summary judgment in favor of the claimant against the defendants in this case. The importance of this case is that it illustrates the interaction between IT investigations and the applications for the appropriate court orders. Without the IT investigation, the court order applications couldn't be made. But without the court order applications, further and subsequent IT investigations couldn't be made either. And finally, it is the IT evidence that made sure that the claimant could prove that the email sent from Mr. Loshi was sent from a spoofed email account. And it was the lack of the equivalent technical evidence that ensured that the defendant failed in their defense because they could not produce technical evidence that the email which Mr. Carey said were coming from his account, in fact, came from his account.